Hi, Assalamualaikum. I'm Jannah. So today we're going to talk about state responsibility. So what is state responsibility? State responsibility is when state breach international obligation, then the state must be responsible for it. It could be bilateral or multilateral, or it could be between two countries or more. In state responsibility, we're going to take a look a lot in article on responsibility for state for internationally wrongful acts. So in order to understand about the state responsibility, there's a few elements that we need to take a look. The first one is the obligations. If the state have breach obligations under a treaty, it is in Article 12, which is breach of international obligations. Then secondly, we take a look at the Article 2 on the wrongful act of the state. And then third, we take a look at the omissions if it is directly committed by the state and directly affecting other state. For instance, breach of treaty. And finally, we take a look if there is any damage that is taken. The damage is taken could be based on the violation of territory and also damage state property. It usually happens with the conduct of tortious acts. Tortious act is an act to actually create harm to someone or to the other state. And then we talk about the imputability. Imputability is if we need to take a look if the act is imputable to the state or not. So, which means that the act causing damage to other state, then the defendant state can be responsible for it. The defendant of the state could be the organ of the state, which is the executive, the military. And then we take a look about the theory of the state responsibility. There is two theory, which is risk theory and also fault theory. In risk theory, it is quite objective, quite direct, which is when the state conduct unlawful act, then the state must be responsible for it. It's objective because we take a look back at the element. If the state have breached any obligation under a treaty, if the omission is directly conducted by the state affecting other state, and also is there any damage that were given. And then in the fault theory, it is quite subjective because we need to take a look if the act is imputable for the state or not, and its emphasis on the elements of the international dolus or niggling culpa. So it's quite subjective because we don't know. In the fault theory, the case study is a Corfu Channel case. In the Corfu Channel case, it's happened between United Kingdom and also Albania, which United Kingdom actually brought the case to ICJ because they believe that Albania has mines that actually bomb their ship. So I have created a video about that. Then we're going to take a look about the video in order to understand more about state responsibility. Thank you.
Hi, I am Shasha. So in this video, I will focus more on internationally wrongful act. Thus, in accordance with that, Article 2 further specify the two constituent elements of an internationally wrongful act. First, whether there is a breach of international obligation by the state or not. Second, whether the internationally wrongful act is attributed to the state under international law. Thus, in order to know whether an act is attributable to the state or not, we have to see the dior bit under Article 8, 9 or 10. Article 8 ILC state that the state will be responsible for the acts public servant or other persons categorized under the three organs executive, legislative and judiciary. Article 9 of ILC means that a conduct is considered as an act of the state if the person or groups exercising the function of the government in absence of the real government officer responsible for such action. Next, Article 10 means that an act will be considered as being done by the state if the doer is in the insurrectional movement when they subsequently become a new government. The state will be responsible by such movement even a wrongful act done by the previous government. Moving on to the next point, circumstances precluding wrongfulness refer to the situation where wrongful acts will be justified and result for the wrongful act to become lawful. These six circumstances are consent, self-defense, countermeasure, force measure, distress, and necessity. As for the consents under Article 20, it is provided that the consents give to carry out the activities that are not prohibited by international law, renders those activities lawful. For instance, consents to allow aircraft to cross the airspace. Next, Article 21 provides that the wrongfulness of an act of the state is precluded if the act is lawful measure of self-defense, and it must be in the Charter of United Nations, which we can refer to Article 51 on the Charter that preserve a state right of the self-defense in the case of armed attack. Next, referring to the Article 22's countermeasures are accepted as defense as long as certain conditions are bound to. As for the force measure, it simply put as when there is unforeseeable circumstances that prevent the state from fulfilling the contract, then such act precludes the wrongfulness. On the other hand, distress in Article 24 is simply put as the wrong your state has no other reasonable way in saving its life. As for the necessity under Article 25, it is the situation where the act becomes lawful, where it is the only means to safeguard an essential interest. For the better understanding about force measure, we refer to the case of guilt. In this case, the Mexican government relied on the circumstances of force measure to preclude its wrongfulness of the destroying the house of British national is an unforeseen event. However, the International Commission held that the wrongfulness will be justified under force measure only if the Mexican government had taken necessary and sufficient measure to avoid such event from happening or avoid severe damage and not by blind negligence of the Mexican government. That's all from me. I will pass the floor to Ivan for further explanation. Thank you.
Assalamualaikum, hola, namaste. I hope you guys are doing good during this lockdown, and it is my pleasure to share with you guys of what have I acquired. My name is Irfan, and my part will be the consequences of internationally wrongful act. I have 6 points. My first point is secession. Under Article 30, the state responsible for the internationally wrongful act is under an obligation to cease that act if it's still continuing and to offer appropriate assurance and guarantees of non-repetition if its circumstances so require. Second point is reparation. Article 31 stated that the responsible state is under an obligation to make full reparation for the injury caused by the internationally wrongful act, whether it is material or moral. Under Article 34, it stated that reparation has 3 forms. The first form is restitution. Under restitution, the responsible state must re-establish the condition to its initial state. This form of reparation is rare because of its complexity. For an example, it is impossible to restitute debt. Second form is satisfaction. Satisfaction relates to non-monetary compensation and would include official apologies, acknowledgement of the breach, or an expression of regret. My third point is just cogent. The concept of just cogent is a set of principles from which no derogation is permitted. Under just cogent, it specifies the prohibition on the use of force, prohibition of international crime and atrocity, and prohibiting the violation of human rights. As a result, an international convention that conflicts with just cogent rule is considered void. My fourth point is diplomatic protection and nationality of claim. Diplomatic protection is a means for a state to take diplomatic and other action against another state on behalf of its national whose right has been violated. Article 44, bracket 1, the responsibility of a state may not be invoked if this claim is not brought in accordance with any applicable rule relating to the nationality of the claim. Diplomatic protection includes, in a broad sense, consular action, severance of diplomatic relations, or economic pressure. The fifth point, the exhaustion of local remedy. According to Article 44, bracket 2, the responsibility of a state may not be invoked if local remedy has not been exhausted. Several important factors where local remedy should be exhausted is to enable the state to have an opportunity to redress the wrong that has occurred within its legal order, and every state needs to respect sovereignty of another state. My last point is the treatment of alien. The entire law of state responsibility for injury to alien is a matter of existence of correlative rights and duties. The state has a right to expect that the alien will follow its local laws, and the state has an obligation to protect the life and property of this alien under the various treaties and conventions of international law.